Welcome to ASG News Updates. Now, the Court of Appeal has lifted orders that were issued by the High Court suspending the implementation of the Social Health Insurance Act, which is set to replace the NHIF Act. In their verdict delivered on Friday, today, 19th January 2024, Justices Patrick Kiage, Pauline Nyamwe and Grace Ngenye ruled that owing to the suspension of the rollout of the new health fund, there is a real and present danger, and I quote, to the health rights of countless citizens who are not parties to the litigation pending before our courts, end of quote. However, Section 26(5) of the Act, which makes registration and contribution a precondition for dealing with or accessing public services from the national and county governments or their entities, and Section 27(4), which provides that a person shall only access healthcare services where their contributions to the Social Health Insurance Fund are up to date and active, remain suspended. Section 47(3), which obligates every Kenyan to be uniquely identified for purposes of provision of health services, also remains suspended according to the ruling. And also, the parties in the case have been granted 7 days to file written submissions on 3 sections of the Social Health Insurance Act that remain suspended. Health Cabinet Secretary Susan Nahomicha moved to the Court of Appeal, arguing that the High Court order had resulted in many Kenyans being denied medical care against the provisions of the Constitution. Through Senior Counsel Fred Ngatia, the Health Cabinet Secretary said the court orders had disenfranchised many Kenyans who were now unable to access medical care since the enactment of the Social Health Insurance Act 2023 repealed the NHIF Act, imploring the court not to allow legal wars to deny Kenyans a constitutional right. Now, the Attorney General, through his lawyer, also pleaded with the court, saying that many patients were hurting and that while the court's decision was being waited upon, the existing orders be lifted.